Welcome to this presentation in which we're going to cover Chapter 13 of our textbook. And this chapter deals with legal responsibilities in travel and tourism. Obviously, when you are in the hospitality industry, many times the customers that you will be serving will be involved in travel and or in tourism. So this is a relevant topic to our course. We're going to divide up the topics in this chapter into 5 subcategories. We're going to talk generally about the topic of travel, then we'll talk about travel agents and another category of travel providers called tour operators. And then we'll talk about common carriers. We'll talk about the tourism part of the travel industry. And then finally, we'll talk about how online travel sales, how they impact the law, or how the law, I guess, impacts them. So let's begin. Okay, so we have the term travel law. No big surprise here. What is travel law? Well, it's laws about travel. And the textbook says it's the laws regulating business and individual behavior in the travel industry. So pretty obvious definition there. And guess what? International travel, also pretty obvious. It involves the ordinances, rules, treaties, and agreements used to regulate the international travel industry. Obviously, this is a huge category because just like international law generally, if I'm traveling to, say, Rome, well, I'm going to have to comply with the laws of Italy, but sometimes the laws of the United States may come into play, and potentially other countries. If I'm, say, passing through France or Spain on my way to Italy, those laws could also impact a particular situation. Maybe I'm dealing with a company that's based in Germany, then the laws of those countries could impact. So this is a relatively simple term, but it's a really, really potentially complex subject. Okay, so let's talk about 5 components that affect the travel industry. One, of course, is that most of the time people plan ahead. I mean, hopefully they plan ahead. That's a good plan when they do so. And so when they do so, many times they're going to be dealing with travel agents. Certainly, the existence of the internet has dramatically increased the number of people who are kind of doing their own travel plans, but still the travel agent is an important component in the travel industry. I think we all know what a travel agent is, but here's a definition if you're a little fuzzy on the details. A travel agent is a professional whose job is to plan and sell travel-related products and services. Let's look at this word for a second. We have the word agent here, and you may recall that we've talked about the word agent before. We talked about it when we used the terms agent and principal. An agent is somebody who has the authority to act on the behalf of the principal. In this case, the principal would be the consumer, the person who is placing the order for a hotel room or an airline ticket or something like that. The agent is a fiduciary of that purchaser of services. So this is an agent who is acting as an agent with respect to travel plans. Okay, we'll talk more about travel agent later on in this presentation. Another category that is important to the travel industry is transportation. We have to get from point A to point B, and sometimes we'll be using if we're a traveler, sometimes we'll be using our personal car, or we'll be walking or hiking, but oftentimes it involves hiring various services. It might be taxis, it might be Ubers, it might be car rentals, airplanes, trains, boats, all kinds of different things can be used, and the choice of transportation that we have can affect the legal responsibilities that we have and that we can expect that travel provider to provide us. Most of the time, if we're traveling, we're going to need a place to stay. And of course, then lodging becomes an issue. In many respects, the lodging issues that we confront in travel are the same issues that we confront when somebody is coming to a hotel just generally. I mean, obviously, in some sense, a person visiting a hotel is traveling. Most of the time, we don't stay in a hotel in our home city. Obviously, people need to eat when they travel, and so food services is an important part of the component. And then many times people are traveling for tourism reasons, or even if they're traveling for business, they may want to take in the sights or see certain aspects of the community, and so they may be interested in seeing attractions and activities along those lines. Again, things that can impact the hospitality industry. So let's talk about the topic of jurisdiction. This is really huge, and there are in law school complete courses on the topic of jurisdiction. So this is not something that can be explained in great detail very simply. Jurisdiction is simply the authority of a court to hear a particular case. And many times when one is traveling, there's lots of different courts that potentially could hear a case. So let's say that Bob is from Virginia, and Bob is traveling to Texas, and he stays in a hotel here. He made his hotel arrangements with a travel agent that is based in Maryland. The hotel that is located in Texas has its corporate headquarters in Delaware. Bob is traveling to Texas on business, and his employer is based in New York State. So you can see there's 5 states there that I came up with really quickly who can have some impact upon where a particular dispute ought to be heard. So let's say Bob gets his way to the hotel, and when he's there, something bad happens to him. Maybe he's mugged in the hotel, maybe stuff is stolen from his room. Whatever happens, it happens, and now he is in a dispute with the hotel. Well, it's a pretty important issue about where the lawsuit is going to proceed. Probably Bob would ideally like it to proceed in Virginia because that's what's most convenient for him. Very likely the hotel would like it to proceed in Texas because that's what's most convenient for it. Plus, it's where the witnesses in the case might be. If the employer is involved, the employer might want it to happen in New York. And if the travel agent perhaps is an issue or perhaps a defendant, he or she may want it to happen in Maryland. It's even possible that it could be heard in Delaware. So there's lots of possibilities here, and you can see different people might be advocating for different places. And so how do you decide? How do you know which is the right place? Or maybe there's more than one right place. We'll talk more about this issue later on in the presentation, but the important thing to keep in mind is that one or more courts are likely to have jurisdiction, and it's important that Bob pick the right court. And if Bob picks the wrong court, it's important that the defendants, probably the hotel, maybe the travel agent in this case, contest that jurisdiction. So this is, again, can be a very hot issue in certain cases. And of course, when you add an international component to it, it even becomes more complex. So what are some things that can come up in international travel disputes? Well, one issue is interconnectivity. If, let's say that I run a guide business, a travel guide business, and we're in, say, Rome, and so I take tourists from this spot to this spot, and maybe I have a business relationship with a bus service, and the bus service carries us from one location to another. But then for parts of the tour, we might be on foot, or perhaps we rent some kind of a boat or something along those lines. And so as I'm providing my services, I'm reliant upon these other services also being available. So if the bus breaks down, it's not really my fault. I'm doing my services as I ought to, but from the perspective of my customers, they see a tour that has gone awry, where they're stranded or they're delayed unnecessarily, and they see me as the person who ought to be able to fix it or stop it from happening in the first place. And so you can see how one service gets connected to another. Let's say as part of my tour, we stop off at a restaurant for lunch. We get there, the restaurant isn't ready to serve us, they don't have the food ready, or perhaps it's closed. Again, another situation wherein my customers are not happy. They may see me as the cause of this problem. But really, each one of the services is somehow connected to another. One person missing, not doing what they're supposed to be doing, can cause the whole system to collapse. We've also talked about jurisdiction, again, suing in the right place. And sometimes, even when you determine what the right place is, it may be inconvenient. If we had made, let's say Bob had been, instead of going to Texas, he had been going to Paris. Well, it's probably pretty prohibitively expensive for Bob to go back and forth from Virginia to Paris to litigate this dispute. He's going to be at a disadvantage because perhaps he doesn't speak French. And so he might decide, well, that's where jurisdiction is. That's what the attorneys tell me. But it's really not worth my time to pursue this dispute because of the expense and the inconvenience that's going to happen if I have to litigate this case in France. Another thing that can come up is terminology differences. Obviously, if you're throwing in different languages and different customs, different understandings, you might have very different experiences. For example, if you are having some kind of all-inclusive hotel experience, and let's say they say breakfast is included. Well, what does it mean that breakfast is included? Is it a hot breakfast with eggs and bacon and sausage and all that kind of stuff? Or is it a roll and a cup of coffee? There might be certain cultural expectations in certain part of the world that is a very simple breakfast, might be very different than the expectations perhaps that might exist in the United States or something like that. The terminology of, say, car size. If I'm renting a car, do the terms that I'm expecting to see, are they compatible with the terms that are actually being used? And so you can see how disputes can arise about that. Sometimes it's unclear who's actually providing the services. For example, if you're participating in a travel package, they're probably not going to list all the names of the restaurants that you're going to visit. For one thing, they may not know what those names are going to be. This might be something that changes and shifts depending upon the season and the busyness of that particular business, and also based upon previous customer comments about that business. And so when you sign up and it says in the brochure that you will have 3 meals a day, you don't know that it will be, Georg's, bistro or something along those lines, compared to, Fritz's beer garden or something along those lines. And so when a problem arises, do you sue Fritz because you got sick at his beer garden, or do you sue the travel provider? All of those things can become an issue. Then, of course, there's all the uncontrollable factors, weather, unrest, problems at the border going from one country to another because there's a long line of people trying to enter or exit the country, or because just the people at immigration control are slow or perhaps unpleasant. Lots of different things that can happen. Mechanical problems with the airplane. All those things can cause schedules to be off, and so you miss that meal or you miss that tour. All of those things can happen. So you can see how disputes are very easy to develop under travel circumstances, especially international travel circumstances. So that's an overview about kind of some of the issues we'll talk about later on. We'll see some of these issues coming up. Let's talk specifically about travel agents and the related category of tour operators. We talked about what a travel agent is. A travel agent is somebody who acts as an agent with respect to the principal, and the principal is the traveler. An agent is going to be the fiduciary of the principal. The agent has the authority to act on the behalf of the principal, the traveler in this case. And so when the agent enters into a contract on behalf of the traveler is bound by it. And therefore the agent has a special responsibility to be the fiduciary of the traveler. So what is a fiduciary? Well, this is somebody who is required to act in the best interest of another, in other words, the principal in this case. And obviously it requires a great deal of trust in that type of relationship. We see fiduciary relationships in many different capacities in the law, but this is just one of those. So the travel agent is the fiduciary of the traveler, but not necessarily of the other side of the transaction. Obviously, you can't really be fiduciaries of both sides of the transaction. As a result of this fiduciary relationship, the travel agent needs to keep the traveler informed about all the various components of the transaction. And this would include insurance options, possible fees and cancellation, penalties, and things along those lines. There are times where travel agents can be the agents of the hospitality business as well. Some states regulate travel agents and tour operators significantly. Texas at this time does not. That doesn't mean that there are not laws in effect. They just aren't specialized or focused exclusively on travel agents and tour operators. Obviously, Texas's contract law and other laws, Deceptive Trade Practice Act, for example, would apply potentially to these types of situations. Most travel agents earn their money through commissions, and it's not commissions typically that the travelers pay to their agents, but what the business pays to the travel agent. So what the airline pays to the travel agent, or what the hotel or the cruise line pays to the travel agent. So you can see this can result in a kind of a conflict of interest. The travel agent wants the traveler to buy services through the entities that pay them the highest commission, which is usually going to be the most expensive trips or the most expensive hotels, but that may not be what the traveler wants. And so the travel agent may be encouraging the traveler to spend more money than the travel agent wants. But again, the travel agent is the fiduciary of the traveler, so he's supposed to be concerned about the best interest of the traveler. So there can be the potential for the travel agent engaging in some self-dealing, making some decisions on his personal behalf instead of the traveler's behalf. So let's consider some of those issues that can come up, what disputes can arise between a traveler and a travel agent. One can be that the promised services don't come to fruition. For example, if you sign up for a cruise and you get on the boat and you have been told there would be certain excursions that would be included, but the cruise line isn't uh, saying that you have already signed up for those services, and yet you feel that you've paid for those. Well, that would be an example of you having a dispute potentially with the travel agent. Another can be that agreed upon pricing is not followed. The travel agent has told you you'd pay this much, but when you arrive at the cruise location or the hotel, they tell you that there will be a different price. So that could be another dispute. There can be misrepresentation. The travel agent says you'll have this type of suite or this type of room on the cruise ship when you get a different type of room, different size, different location, those types of issues. The travel agent may not have disclosed certain information. For example, you tell them that you want to visit someplace in Africa. Well, you are sent to a country that is very dangerous at this particular time. The travel agent should have perhaps disclosed the danger aspects. Of course, on the other hand, travel agents aren't going to be responsible for the negligence of others. So if the travel agent books you in a hotel that there's no reason to think is going to be dangerous, and once the traveler gets to the hotel, he's mugged or he's had his stuff stolen, well, the travel agent is an insurer for that particular hotel. The traveler can sue the hotel perhaps for negligence, but the travel agent is only going to be responsible if they knew about the risk and didn't tell the traveler, or they should have known about the risk. And if they had known about the risk, they would have told the traveler. So there is some potential for liability, but on the other end of things, a travel agent isn't all-knowing, doesn't have a crystal ball, can't predict the future. And finally, a travel agent can be negligent. A travel agent can make a mistake. Instead of reserving 2 rooms, they only reserve 1 room. Instead of reserving it for this night, for Tuesday and Wednesday night, they reserve it for Wednesday and Thursday night. They can make mistakes like anybody else. Those would be examples of negligence. Negligence is a tort, and that can result in liability for the travel agent. This is just a partial list of the things that can come up, obviously. A class action lawsuit can come up. This can happen when a bunch of people are injured. Oftentimes their individual injuries are relatively small, and they file a lawsuit because their collective injuries can be significant. So this could be against a travel agent, but it could also be against, say, a hotel or a cruise line. Let's say lots of people are on a cruise ship. They all are eating the same food, and a large percentage of the people on the cruise ship get sick, some type of food poisoning. And of course that involves a lot of discomfort for them, and it messes up their vacation. Well, the harm that each one of them experiences is probably not huge, maybe a few $100s, maybe $1,000 or $2. Hardly worth most people's time to pursue a lawsuit. But if you have, 100 or 200 people in that situation, suddenly there may be a sufficient financial stake to motivate that type of lawsuit. Class action law is really complex and really beyond the scope of this class. There's lots of things that the parties who want to advance a class action have to demonstrate to the court before they can proceed. But at least there's the possibility that such a lawsuit can happen in the travel industry. So we've talked about travel agents. Let's change gears and talk a little bit about tour operators. What is a tour operator? Well, it's a company that is involved in planning and packaging and marketing various travel services. And typically these packages are going to involve transportation, oftentimes meals, hotels, and activities. They are similar in some respects to travel agents, but there's important differences as well. For one thing, a travel agent usually doesn't own the service that he or she is marketing to the traveler. Instead, he is getting a commission. It's someone else owns that service. Well, a tour operator oftentimes will buy the hotel rooms in a block, or reserve the seats in a block and then sell them to customers. So they are acting as the vendors, not just as the agents. They are the principals of their own transactions. So in some sense, they have an arm's length relationship with the traveler because they are negotiating a contract with the traveler. Both the traveler and the tour operator are principals. And typically they don't earn a commission because they are selling the service. And so that they would have to be paying themselves a commission essentially. So what are the issues that we see with tour operators? Well, they're very similar, as you can see, to the issues that we saw with respect to travel agents. Non-payment for prearranged services. So let's say the customers don't pay for those services that have been prearranged. Obviously, that can impact a hospitality business that may have entered into a contract with the tour operator. Of course, the problem isn't always with the travelers. It could also be with the services that the tour operator have arranged. Maybe they aren't provided, or they're not provided at the level that was expected. So this again could be that the hospitality businesses that the tour operator has negotiated with have not performed. We'll talk about adhesion contracts in a second, so let's save that issue. Of course, there can be injury or accident. The plane can crash, the boat can crash, there can be a fire in the hotel. All of those things can happen, and the tour operator potentially could be liable. Of course, the tour operator is probably not going to be liable if I get food poisoning at a restaurant, especially if the tour operator hasn't had a history of problems with that particular restaurant. I can sue the restaurant, but the tour operator probably isn't going to be responsible. Now, if the tour operator continues to use that restaurant despite the fact that there have been these incidents, then there's the potential that the tour operator could be held liable. And of course, there can be misrepresentations. If the tour operator tells me I'm going to have a suite of rooms in the hotel and I have a very small room, that's a misrepresentation. or if they tell me that I'm going to have 3 meals a day and there's really only 2 meals a day, then that would be an indication of a misrepresentation. If they say that the property where I'm staying it has beach access and it doesn't, that would be a misrepresentation. Generally speaking, especially in Texas, contract law principles are going to control whether there's a breach of the agreement or not. So we would look to what the particular aspects of that contract are between the tour operator and the traveler to see if there's been a breach. And of course, the hospitality business can perceive that there's a breach of the contract that it enters into with the tour operator. So that can be another contract that can be breached. Okay, so I kind of saved this one, number 3 here. Let's talk about adhesion contracts. Here's a definition. I tweaked this definition a little bit. I did not completely agree with what the textbook said. What is an adhesion contract? Well, the first thing to say about adhesion contracts is that they are not unique to travel or to the hospitality business. They're a thing everywhere. This is a general contract term. So an adhesion contract is a contract whose terms are not truly negotiated or bargained between the parties. It's kind of a take it or leave it type of situation. And as a result of the fact that they're not bargained, it's possible for an adhesion contract to be very one-sided to really benefit the person who wrote the contract. And so sometimes courts do not enforce adhesion contracts. Having said that, lots and lots of adhesion contracts are completely enforceable. The reality is that when you enter into a contract with American Airlines, for example, for travel, you aren't given the opportunity to negotiate over the terms of the agreement, right? You can't say to the travel agent or to the ticket agent, well, I don't like this particular provision. I want to change it. No, the representative would say, well, you don't have to buy the ticket if you don't want to, but this is the deal. If you don't like it, go to another airlines and see if they'll give you what you want. So adhesion or take it or leave it contracts are very, very common in the travel industry as well as other industries. It is useful, though, to keep in mind that when you are the hospitality business who is offering an adhesion contract, you want to make sure that it's not too one-sided, because that can cause the possibility of a court finding it unenforceable. So be on the lookout for contracts that favor the drafter too much. Sometimes people travel, not surprisingly, for their employment. They may be employed by the government or maybe by a corporation or some other entity. When a person is traveling for their employer, the employer has obligations towards that employee to provide them with support in crisis situations, to assist them in extricating themselves, say in a natural disaster circumstance or in a civil unrest circumstance. So that's an important thing to keep in mind, both for the traveler as well as for the hospitality business, to keep in mind. So now we're going to flip and talk about transportation, specifically the role of common carriers in this situation. So what is a common carrier? Well, it's a business typically that is in the regular business of transporting people or freight for a fee. So they are a carrier of stuff or human beings, and they do it for lots of different people. So they're a common carrier. So imagine UPS or FedEx, they are a common carrier. They carry freight items from pretty much anybody who wants to move something from one place to another. When you're on the highway, you might see a Walmart truck, and that Walmart truck probably looks just like a UPS truck, except of course it says Walmart on it. But it's different. It's not a common carrier because the items on that truck are going to be Walmart items or maybe Sam's Club's items. They're not going to be carrying your letter to Great Aunt Maybell or something that Kroger wants to transport from one place to another. They're going to be just Walmart stuff. So not all trucks or buses or whatever are common carriers, but certainly many are. So cruise ships would be common carriers. The airlines would be common carriers. Greyhound would be a common carrier. Things like that would be. In fact, most means of transportation that are travel related would be common carriers. One exception would be rental cars, because a rental car typically just carries one person or one family, and the other items carry many people, oftentimes people who are not connected to one another. Generally speaking, common carriers cannot turn customers away unless, of course, they don't have space or the customer is disruptive or something along those lines. So American Airlines can't say, we don't want to serve redheaded people anymore, or we don't want to handle people who have disabilities, or we don't want to handle people of that ethnicity. No, they have to treat people who are behaving according to the rules that are reasonable in the circumstances. They have to provide services for those people. Another function of common carriers is that there's a high expectation on them in terms of safety. People are putting their well-being in the hands of the common carrier, and so there's a high level of trust there. Obviously, when we are traveling, there's lots of risks. The airplane can crash, the boat can sink, the train can derail. Lots of risks associated with that, and the passenger has very, very little control to ensure that that doesn't happen. And so the onus is really put upon that carrier to be very, very safe. In many respects, that's a similar responsibility to what we see with innkeepers, that they have those same duties. And you can see the parallels between why you would want to have a high level of care in both situations. So again, here are some traditional entities that act as common carriers. Because of the safety aspects of the transportation industry, it's obviously highly regulated, lots of rules about it. Some of these industries can be subsidized by the government. The best case is probably the trains, that they get a significant amount of subsidy. And even the ones that aren't subsidized, though, are highly regulated, sometimes for safety purposes, sometimes for other purposes. Let's talk about the Warsaw Convention. This is kind of a controversial thing. It was passed back, I think, in the early 1900s. This was a convention, and when we see the term convention, we're not talking about like, the travel agent convention or the, when we use convention, this means like a treaty. It's not a group of people coming together in a hotel type thing. So it's a convention, a treaty. And many times treaties are named after the city where the various countries got together to discuss it. So as you can see, this particular convention, this particular treaty was signed in Warsaw, Poland. And it sets the limits on airlines, and it controls how international airline travel will happen. Obviously, airline as a commercial enterprise was in the fairly early stages at this time, and so some of the remedies and resolutions that are related to this might seem kind of dated and inadequate at this time, but they continue to be in force in any flight that you take that has some kind of international component. If you start in the United States and you end in the United States on your flight, you don't leave the United States during your flight, then the Warsaw Convention does not apply to you. The federal law will apply to you. But if you do veer out of the United States during your flight, then the Warsaw Convention would apply. Generally speaking, it's more advantageous for travelers to have federal law apply to them instead of the Warsaw Convention. The U.S. is a signatory or a signer to this treaty, to this Warsaw Convention. And so we are bound by that as residents and citizens of the United States and travelers who are traveling on U.S. Airlines and things like that. Let's talk about a tariff. A tariff, of course, we talk about tariffs in terms of trade issues. We're not talking about it from that perspective, though. We're talking about it from the perspective of airline travel. A tariff is the contract between the airline and each one of its passengers. When you buy a ticket on an airline, the passenger is basically agreeing to those terms, is entering into that contract. So this is the term for this particular type of contract. Let's talk about the term maritime law. This is kind of a weird word. You can see, though, in the word maritime, you can see the word, the beginning of the word marine, sea-related things. And again, this has to do with all of the laws that relate to navigable water. So bodies of water that are deep enough that a ship can navigate through them. And so this involves domestic rules as well as international rules relating to this topic. One area that we see maritime rules coming into play in the travel industry is with cruise ships. Cruise ships are obviously can only be in navigable waters, and in many cases a cruise ship will leave the domestic waters of one country and go to the waters of another country, and so international law definitely becomes important in those circumstances. A cruise ship is obviously more than a ship. It basically, in many cases, is like a hotel. It provides food and entertainment and various leisure time activities. Obviously, it provides places for people to sleep. And so it has many additional functions, and all of those will be related to the maritime law. So once that cruise ship is out of port, many rules that might have applied to a hotel on land in that particular port are not going to apply to that cruise ship. Let's look at some of the issues that can come up in this context, and we'll see some of these issues are similar to issues that we've talked about with respect to travel agents and tour operators. We've already talked about the idea of legal jurisdiction and how complicated that topic can be. That is definitely true in the transportation industry. I mean, by definition, in the transportation industry, you're moving from one place to another. So which place has jurisdiction? The place where you started or the place where you ended, or maybe another place entirely? As a result of this confusion, it's not at all unusual for the contract that establishes that business relationship, that that rental car arrangement or that cruise ship purchase may well state where jurisdiction is going to exist, and in most cases that is going to be binding on the parties. Sometimes transportation industries will overbook. They do that because there will typically be a certain number of people who will change their minds and decide not to go. Perhaps they missed the flight, perhaps they changed their minds, perhaps it was not a convenient time for them after all. And so that's kind of a way to manage the cost of the business, because if they didn't overbook, they would be essentially, in many cases, having empty seats that they could have otherwise filled. And so that's a lost opportunity for the airline. Generally speaking, airlines are not required by federal law to pay passengers if a flight is canceled because of factors outside of their control. For example, weather delays, or even busy travel at that particular hotel that causes planes not to be able to take off at certain time periods. That doesn't mean the airlines won't do something for those travelers, but they're not required to under law. Federal law, however, does place some responsibilities and financial responsibilities on airlines when overbooking occurs and a person is needing to or is not being given the opportunity to ride on the plane even though he or she has a contract with the airline. And there's specific ways that overbooking process is resolved. Airlines have different ways of doing it, but there are definitely federal laws that impact that. Another area of responsibility is with respect to luggage, or baggage in this case. We see this as a bailment. The bailor, the passenger, has left the bailment, in this case the bag, with the bailee, the airline or the cruise ship or the bus service or the train service. The expectation is that bailee will take a good care of that item, but things happen. Sometimes it's the fault of the bailee, sometimes it's not. In the United States, there's a statutory limit to the liability that an airline can have if something happens to the bag. It's capped at $2,500 per passenger. That's not per bag, but per passenger. If it is an international flight, then the Warsaw Convention would apply, and the cap is significantly less. Because of weather issues and malfunctions of equipment, things along those lines, sometimes it's necessary to have a change in itinerary, or perhaps a passenger gets sick on the plane, for example. It's a good idea when you are negotiating contracts like that to anticipate these problems so that you will know what your responsibilities are and what your contracting party's responsibilities are. Now, obviously, you can't negotiate with the airline about that, but when you are the hospitality provider, you definitely can address those issues in your agreement with the traveler. Then there can be industry-specific issues, just like we talked about with the innkeeper. The common carrier is held to a very high safety standard. If they don't meet that standard, then of course liability can accrue to that particular common carrier. So we've talked about travel generally, we've talked about travel agents and tour operators, and then we've talked about common carriers. We're going to switch gears a little bit and talk about tourism, which of course is travel for pleasure. One category of travel for pleasure is traveling for gaming. We think about maybe Atlantic City or Las Vegas, or perhaps Choctaw Casino just north of here. Gaming, of course, is where we have legalized gambling. And so there's kind of three common buckets for tourism-related industries. One is, of course, gaming establishments. Casinos is usually what we think of when we think about that. Also, we have resorts. And finally, we have amusement parks. Gaming industries are highly, highly regulated. Very significant number of rules about how those industries have to be organized, and many times they are to protect the interests of the consumer and also to ensure that organized crime doesn't get involved. Also, they are to provide safety for the workers in that industry as well as the consumers in that industry. We see in our part of the country that most of our gambling opportunities outside of horse races and lotteries are going to be in Native American tribe casinos in the area. That's an important source of gaming in the United States. It has to do with the fact that Native American tribes are in many senses nations within our larger nation, and as they are nations, they have a fair amount of autonomy to organize their own affairs, and so they can, in many cases, establish lawful gambling within the boundaries of their territory. It's a pretty complex issue when they can do that and how they can do that. Certainly it's a controversial issue, but it is something that has been successfully done in many, many places in Oklahoma. It has not yet been successfully done in Texas, although there have been attempts to do that. We also see some of that in Louisiana as well. So let's consider the potential liability issues that have to do with those types of casinos. One can be concerns about consumers who have maybe addiction to gambling. They find it difficult to walk away from the gaming environment. And what responsibility does the gaming business have to assist that person in removing himself or herself from the dangerous circumstances? After all, gaming establishments, like all other businesses, are interested in attracting as many customers as they can and keeping those customers for as long as they can. And gambling industries have been very effective at marketing their product in such a way to encourage people to stay in those facilities. If you've ever been to a casino, you know that you're not able to see outside the casino, so you can lose track of whether it's day or night. There aren't going to be clocks posted on the walls. Again, that's an attempt to maybe cause you, or not cause you, but um, not ground you in what time of day it is. Many times these facilities if you're doing the uh, uh, slot machines, are very bright and colorful with sounds and motions and interesting visuals, again, designed to appeal to you, to make you want to continue participating in that activity. And some people say, well, that's just encouraging people who have a gambling disorder to continue to gamble despite the fact that it is dangerous for them to do so. It's an area of the law that is still in evolution to see where those lines might be, but I think that it's an important thing to consider, how a gaming business will approach that issue. And of course, this is a hospitality business. Gaming industries are oftentimes in hotels, and this is a service that is provided to guests, much like a restaurant or a tour of a natural wonder might be used for guest entertainment. Another concern can be employee working conditions. Many casinos are very smoky places. Um, for whatever reason, many people who enjoy gambling also enjoy um, cigarettes or other types of lawful tobacco products. And those can cause secondhand smoke issues for employees who might be spending, 8 hours a day in this environment. Another concern can be sexual harassment. Most gambling places, there is alcohol available to guests, and sometimes it's at a relatively inexpensive price, sometimes even free. And so, with the use of alcohol, sometimes people's inhibitions are lowered, and they may take actions that they otherwise would not, and that might be harassing or uncomfortable for an employee. And so that can be another issue. Criminal conduct can also occur. You could have people coming into a gambling establishment and robbing it, or you could have employees who are involved in criminal activity, perhaps rigging the games or things along those lines. So employees can be both the victims and the perpetrators of criminal conduct. Internet gambling is another part of the gaming industry. At this time, it is pretty unregulated. I think that many of our legislators would like to regulate it. It's a tricky one to regulate because obviously stuff on the internet can be difficult to regulate, and many times these industries are not located in the United States. But that's something that may happen in the future. Okay, so let's talk about another type of tourism. Let's talk about resort-based tourism. Let's first of all consider what a resort is. A resort is some type of operation that offers some type of food and beverage, some type of lodging and entertainment. So a resort could be a full-service hotel on the beach, for example. Or it could be a ski slope slash hotel in the mountains in Colorado. Those would be examples of resorts. Walt Disney World would be an example of a resort. Lots of different types of resorts, and they can appear very expensive places or very modest places, can meet those definitions. Within a resort, sometimes you will find timeshare properties. And you can tell by the name that what we're doing here is we aren't sharing, it's not like an apartment or a condominium arrangement where I have my space and you have your space and Bob has his space. But our spaces are on top of each other. The difference is the time. So I might, quote unquote, own my timeshare for 2 weeks in January, and you might, quote unquote, own that same piece of land for the other 2 weeks in January. And so that is the idea behind timeshares, and that you are committed to a particular time of week, excuse me, a particular time each year to use that particular property. Um, and as I said before, these are oftentimes located in desirable destinations. They can be within larger resorts. Some resorts are just going to be timeshare properties. Some resorts are going to be mixed. There'll be some timeshare properties and some hotels and some condominiums and other facilities. So what are the concerns that can arise when we're talking about timeshare or resort operations? Well, one concern can be how are these resorts impacting the environment and also the economic viability of that larger community. And certainly there can be regulations, especially with respect to environmental protections, because many times these resorts are in places that might have a fragile ecosystem, and if too many people descend upon this particular place, it might cause there to be damage to that system, to the wildlife or to the flora and fauna that is found there. Another issue can be deceptive sales tactics. Some timeshare and or resort properties have a reputation for being very aggressive in how they market their particular products. Strong arm tactics, some level of deception has been found in certain circumstances. Texas does have a timeshare law that relates to this particular circumstance. It protects people who buy a timeshare, giving them at least 5 days to change their mind without any financial repercussions. Also, the sellers of the timeshares are prohibited from engaging in certain deceptive trade practices. This is some protection to the consumer. This is perceived as an area where the consumer might be especially vulnerable. Let me just show you what the statute looks like. Here we have it. It is in the property code, and it's called the Texas Timeshare Act. Again, I'm just going to show you. It's obviously a very detailed statute with lots of different provisions, kind of beyond the course of this scope to see all the details. But the important thing here is that it puts duties and response. Here's the deceptive trade practices part of it. It puts duties upon the marketers of the business to fulfill the terms that they have said that they would fulfill within the contract. Okay, so you do need to know there is a Texas Timeshare Act, and you do need to know these two provisions. So what are the rights, I guess related to this is going to be considering what the rights can be for the owners of the timeshare if there's a default by the developer. Consider this for a second. You paid a significant amount of money to have, say, the first 2 weeks of every January to have access to your timeshare property, but the developer goes bankrupt. Well, have you just lost your access to that property or not? How is that going to play out? And you can see how this can be a source of litigation. One clause that is sometimes in the contracts that the potential travelers enter into with the developer can be a non-disturbance clause. This is a way to reduce the likelihood that the consumer will lose his access to his timeshare. So what is a non-disturbance clause? Well, it's a clause in a contract that stipulates that leases or other ownership investments in the property, like the timeshare, will be allowed to continue uninterrupted in the event of a default or insolvency by the landlord or the seller. So that person ideally or hopefully will be able to continue despite the bankruptcy situation. A third type of tourism industry, we've talked about gaming, we've talked about resorts and timeshares. Well, a third type would be the amusement park. Of course, this is something, the local one we have here is, of course, Six Flags. We have others, though, here locally. I would say that a Great Wolf Lodge is an amusement park. Anyway, and there can be smaller ones as well, of course. What is an amusement park? It's an entertainment facility offering rides, games, food, and sometimes shows. A special category of amusement parks can be theme parks. What is a theme park? Well, it's an amusement park that is arranged around a theme. So examples of themed amusement parks would be Walt Disney World or Universal Studios. Again, they're all themed around those particular topics. And obviously, these also function, especially the Walt Disney World and Universal Studio. I don't mean to say studies here, that should be studios. Sorry about that. Studios. Can also be resorts, and they can also have timeshares on it. So anyway, can be multiple types of tourism businesses kind of rolled into one. One concern, of course, in the amusement park business is the safety of the rides. Sometimes people get badly injured or even killed on some of these rides. Sometimes it's the fault of the person riding it. Sometimes it's the fault of the machine. Sometimes it's the fault of the employee who secured the belt or did whatever they were supposed to with respect to that. Obviously, it's crucially important, not only from a liability standpoint, but also from an attracting customer standpoint, to have very, very safe rides. And so that needs to be a foremost concern for the hospitality business. Another issue that can come up is the performance of the parties to the contract. The guest, the person who has purchased a ticket to the particular amusement park, is expected to behave in a certain way. If I buy a ticket and then go on to the property and act in a disruptive manner, get into fights, try to steal from people, use profanity, became generally abusive, I'm going to be asked to leave because I have violated the terms of my agreement. Similarly, if I have purchased a ticket to go to a particular amusement park, and let's say there's one featured big ride at the amusement park and it's shut down, I'm not likely to be very happy. And in fact, I might complain about that and want to have a refund. Sometimes amusements will close, for example, if there's a thunderstorm a certain distance away. So there can be lots of different points of contention between the guests and the business that is running the amusement park. There can be, of course, litigation relating to employee training. If the employees aren't receiving adequate training, they themselves might be at risk of harm, or they might actually injure other folks. So that's obviously an important function at the amusement park. So we've talked about travel generally, travel agents and tour operators, common carriers, and the tourism business. We have one final topic, which is online travel sales. So let's dive into that topic. The Global Distribution Center is an interconnected computer system that connects travel professionals worldwide to those companies selling travel services. Now, of course, many of those companies that are selling travel services are connected through the web, and so it's pretty easy from one to talk to the other, but others might just be connected, say, through an email address. And so when a particular ticket is purchased, there might be some lag time between the time that I purchased that ticket in Frisco, Texas, and the hotel in, we'll say, Munich, Germany, actually gets a record that I have purchased at. It might be a few seconds, or it might be even a day or two before that gets recorded. And so that can be an issue with a GDS system. Here we go. So let's look again at some of those issues. One issue that can come up is, who are the parties to the contract? We know that the consumer is a party, but is the consumer entering into a contract with that particular hotel? Maybe that particular hotel is a franchise. Is that clear that he's entering into the contract with the franchise versus the parent company? Or is he entering into contract with the parent company? Or is he entering into a contract with the tour operator? Lots of different possibilities there, and it's not always clear. We already talked about the data interface issues. The lag time could cause a room to become double booked. I purchased the hotel room, but the hotel doesn't actually get notice of it until several hours later, and in the interim, someone else has purchased that same hotel room for that same night. There can be data security issues. Is my credit card information being uh, uh, carried through these systems in a safe way? Once that information, let's assume it is carried in a safe way, could that end user or an intermediate user use my data um, to sell it to some other type of business and things along those lines? So there can be issues about who owns the data, is it secure, how is that data going to be used? And then we'll talk about form selection in the next slide. And also a lawful advertising. Are the pictures that we see on the internet about that particular location, are they accurate? Are they amenities that are described in the website accurate, current in terms of what's available right now? There is in the law recognized the idea of puffery or puffing, and that is the idea that it's reasonable that an advertiser is going to put its best foot forward. It's not going to show the ugly smokestack. Instead, it's going to frame its pictures in such a way that it's showing the beautiful lake or something along those lines. But puffery can cross a line and become deceptive and unlawful. Generally, puffery is going to involve opinion more than fact, or being careful about how you angle pictures and things like that. But certainly there is the risk of crossing the line and actually deceiving customers. Go back here. This is something we've talked about a few times. We're on or on topic number 4 here. Something we've talked about several times, the topic of jurisdiction. And I've said at certain points that the parties can decide this issue through their contract. Well, there's a particular name for this provision in a contract. It's called forum selection or venue selection. And this is actually a clause in a contract in which the parties agree that any disputes that happen between the parties will be resolved in this or that particular location. And so that can be a relatively straightforward way of resolving the problem of jurisdiction. Generally speaking, obviously the resolution is going to favor not the traveler, because the traveler isn't drafting this language, but the hospitality provider or the travel agent or the tour operator, more so than the consumer. So now we've talked about the 5 topics that we were going to be discussing in this chapter. I hope that this information has been helpful to you. As always, if you have any questions about the material, please don't hesitate to reach out to me via email, or even better, come by my office hours to discuss it in more detail. I thank you for your attention, and I hope you have a great day.